Okay.
Um,
So I think.
Good afternoon,
Yes, yes.
Satya Ranjan sir.
Very good afternoon.
And here I am Dr. Kumareshan sir.
Sir.
Sir, now your video is not visible, sir. Mr. Satyan, sir.
Sir, it's visible only, sir.
Only screen is visible, video is not visible to me.
It's visible, sir. It's visible.
Okay. Let him.
Okay.
Yes, sir. Now the time is 2 o'clock. Shall we start, sir?
Yes, sir. We'll start.
Yes,
Sir. We'll
yes,
start,
please.
sir.
Yes,
Please.
sir. Thank you, sir. So to start with, again, I request all the participants to kindly ensure that your mic is being muted for the smooth conduct of this session. Honorable Vice Chancellor, Madam, respected Registrar, Madam, and today's resource person, Mr. Satya Ranjan Mishra, sir, and all other participants, and my dear fellow friends. We are very good afternoon to one and all present here. Mr. Satya Ranjan Mishra, sir, is working as a senior assistant professor of commerce in Gujarat National University. He has around 15 years of experience in teaching at TNNLU. He has taught various courses on income tax, accounting, finance, GST, capital markets, forensic accounting, etc. Sir has delivered guest lectures at various institutions and has also offered at GNLU a certified training program on the income tax in April 2021, which was very well received, such as received by the participants. And sir has also published so many research papers in reputed publishers such as Oxford University Press, Eastern Book Company, GNLU Law Journals, Department of Politics, etc., etc. So with this small introduction about our today's resource person, now I am handing over the session to Dr. Satya Ranjan sir to deliver the talk on the theme Law and Commerce. Over to you, sir.
Thank you so much, sir, and thank you very much once again for a very generous introduction that you have given for me. First of all, I really congratulate each of your participants for participating in such a wonderful FDP, which is, I think, opening up spheres of interdisciplinary education and really giving very good focus on how interdisciplining can happen in legal education. So I think my best regards for Elizabeth ma'am for initiating such a wonderful FDP and the team of TNNLU for wonderfully conducting it. Kumareshan sir, we had a very good discussion in the past, and it's actually taking that forward. So it's really very, very good. Can I just have a quick word about the participants? I think I can see a lot of participants from around the national law universities in the country. So we have law teachers basically, or is the group also having teachers who are in interdisciplinary education or legal or other education systems?
I think mostly law teachers, sir.
Okay.
Mostly
law teachers. Okay.
Yes.
So once again, good afternoon to all. Another disclaimer that I would like to run here is that I generally prefer a clean shaven face, but because of a religious event and a compulsion, it could not be done today. So kindly bear with this weird look that I'm wearing today. So coming straight to the point and straight to the issue that is in hand, is that how law and commerce are integrated, how law and commerce are intertwined with each other, how law and legal education and commerce education go hand in hand. Let me immediately focus on some aspects of the education of law and commerce, which inherently makes it interdisciplinary and inherently makes it integrated. I will first of all focus on this aspect that that business legal education is very, very fundamental in shaping the career of a modern lawyer. All of us are associated with legal education. We know our graduates are going to maybe law firms, they are going to judiciary, they are going to regulators, they are going to banking institutions. So unless and until they are quite well versed with business education also and legal education also, because most of the clients of the law firms, they are businesses only. Corporates become clients of the law firms. Similarly, banks themselves are business units. So their problems, their challenges are actually business legal challenges. They face a lot of complex business legal challenges for which they require professionals which are really very, very good in both the spheres of business as well as law, right? Therefore, an integrated education is very, very fundamental, especially business and legal education is very, very fundamental. Second aspect that I would like to highlight is that business and law are quite interdisciplined in the business law subjects that we always talk about, like for instance, law of contracts, maybe Partnership Act, Sale of Goods Act, Companies Act, Securities Law, Income Tax Act, GST or indirect taxes. So in all these business laws, business is an inherent unit and law is an inherent unit. So the interdisciplining is there also in those areas of law or those law subjects as well. Those are especially called commercial laws or business laws. Now you find increased interest of participants in the LLB programs or LLM programs. These days, they very much like business law programs. There are many takers of business law programs. They very clearly know that there are a lot of opportunities that are lying ahead for career or for having a good area of practice after they pass out. So it is quite fundamental for any lawyer who wants to aspire to make a career in business law. Then the fundamental or the basic tenet on which business legal education is built around, as I always tell, is around the idea of economic justice. So when I talk about economic justice, what do I mean? I mean the economic justice which is mentioned in the preamble. So economic justice for me means economic justice for the corporate also, who is the richer participant in the economic system, and the poorest worker, who is the poorest participant in the economic system. So because the laws or justice education has to cater to both the corporates also and the poorest of the poor laborer also. So economic justice is the fundamental idea around which entire business education is based. So let me take an example of economic justice, what I mean to say when I talk about economic justice. See, the right of a single individual cannot be violated. So is the right of a corporate. Can the right of a corporate, howsoever rich it may be, can it be violated by anybody? The Constitution itself guarantees them the rights of freedom of trade, freedom of commerce, freedom of intercourse, trade, commerce, and intercourse. You find Articles 301 to 307 of the Indian Constitution dealing with freedom of trade, commerce, and intercourse. Though there are reasonable restrictions put in there, but nobody can hinder freedom of trade, nobody can hinder freedom of commerce. Now, the laws right from the Constitution of India are actually facilitating freedom of trade and freedom of commerce. So business education is actually centered around these concepts, these ideas, because unless and until you provide a very conducive system for development of trade, development of commerce, there cannot be economic progress. There cannot be economic development. Of late, economic progress and economic development has become a huge necessity to sustain the nation. We have growing needs of we have growing economic needs of financial needs, which can be met only by good numbers of entrepreneurs, good numbers of businesses, good numbers of traders. Now, therefore, trade, commerce, and these are very, very important aspects which cannot be ignored. But what we generally observe in the national law university system, or for that matter in the law university system, is that people generally have a dislike towards business legal education. They think that it is serving the interest of the corporates and it is serving the interest of the rich businessmen. But that is not the truth. That is actually a myth. So that is actually a myth. It's not true. Business legal education, yeah. Business legal education does not cater to the needs of corporates alone. As I told you, our graduates are not only serving the law firms whose clients are business houses, our graduates are also serving the judiciary. They are also serving the regulators like SEBI, RBI, etc. So they are actually contributing to greater social interest and greater public interest, right? Therefore, there is without any doubt a very important need that is there for business legal education. Now, going to the next aspect, I would like to just tell you that very few national law universities today have BCom LLB or BBA LLB kind of courses. Most of the national law universities today, they teach BA LLB. So largely what we find, the domains such as business administration, the domains such as commerce, accounting, finance, these remain untouched by lawyers today. The lawyers of the day do not get a feel of these, these disciplines, these domains. Therefore, for creating all-round lawyers or all-round professionals, to diversify the interest areas of the professionals, we need to impart education which is also in these areas. And I really congratulate Tamil Nadu National Law University. GNLU has become LLB program, TNNLU, CNLU, few NLUs like this, they are offering BCom LLB program. There are few NLUs who are offering BBA LLB programs as well. So, these programs, what you find, if you're talking about commerce and law, you find mostly, many areas of interest that can be created in the minds of the graduates if they pursue this. From our experience, we can say that, the graduates who are pursuing our programs, they are quite interested in law of contracts. They're quite interested in company law. They're interested in income tax, GST, customs, excise, forensic accounting. They're interested in, practicing in the areas of economic offenses, securities and investment laws, banking laws, SEBI regulations. They're interested in becoming good resolution professionals, or they're interested in becoming good corporate lawyers, assisting the insolvency and bankruptcy proceedings. In the resolution process, they want to be a participant. They're practicing in labor laws. They're practicing in trade WTO laws. They are quite interested in commercial arbitration, ISG, CISG, corporate mergers, acquisitions, etc. So there's a huge dearth of talent in the NLU setup as of the day in these areas which are very, very vital for law firms, or which are very, very vital for the day of practice. So we find there is a huge dearth of talent there. Now, the reason for it is that, the traditional LLB courses that we have, those traditional LLB courses are actually built around BA LLB courses. Those are actually, because these are BA LLB courses. So we find there is a huge dearth of talent in these areas, because if you do not orient them right from the beginning, they do not create interest in such areas at a later stage of their career. So when we are teaching them, let's say, science from their beginning, they become quite interested in space laws, right? If we teach them commerce from the beginning, they become very, very interested in mergers and acquisitions. income tax, direct taxes, indirect taxes, all kinds of commercial laws they become interested in at a later stage of their career. Therefore, we need to blend these two education systems quite well to achieve the desired results that we need to have. Now, after this much of introduction regarding the requirement or the need for commerce and legal education, or business legal education as I call it, I go to the aspect of curriculum designing. What should be the focus of curriculum designing in these courses? And I will also towards the middle of the lecture or towards the middle of the session, I will also try and discuss a method that I generally follow to create a 360-degree understanding of the students with regard to any complex business legal issue. How the students are going to appreciate a business legal issue 360-degree. So I really focus on that kind of teaching methodology, which I will also try to share with you if you permit, Kumareshan sir. I'll also discuss a teaching methodology in that regard. Now, in terms of curriculum designing, what we find that we need a 360-degree curriculum for them. I mean to say, we don't need to focus on a single aspect or single dimension of the issue. We need to give a 360-degree perspective of everything that we are discussing with them, because we never know which part of the problem or which dimension of the problem they are going to approach in the future. So we may think that they will always be lawyers, but they may find themselves as bankers. So if we have not prepared them to deal with the banker's perspective of that particular issue, then they will not succeed in what they're interested in doing. Similarly, we need to place adequate emphasis on complex business legal issues and problems. We need to recognize laws which are applicable to a given business legal problem. We need to have latest bills, legislations, judgments, regulations, rules, etc. And we need to give good focus on career prospects, research, research trends that are there, and what are the upcoming issues that are there with regard to that particular subject. So suppose I am designing a finance course, I need to tell them what are the career prospects in financial laws, what are the upcoming issues there on which they can do research and create publications. I need to educate my students with regard to that also. Regarding teaching and evaluation methodologies, there are few teaching and evaluation methodologies I would like to suggest this house, because you all are quite experts in your own domain. I don't need to really guide you anything with regard to that, but I can really compliment you with your efforts with few new techniques that we have tried and we have succeeded in doing that. Most of you, or almost all of you, are following case method. So here, when it comes to the legal cases, you have the court judgments which you analyze, and you do that IRAC analysis and you analyze the court judgments. But in our business education, we really follow something called a case study method. Now, case study is different from a court case in the sense that we write the case study in the form of a story. It is generally a storytelling method that we follow in terms of writing a case study. Now, that method is quite popular in business schools, and that method is also very popular in national law universities or law schools of the day. Students find it very interesting. Through a case study, what I will do, I will try to discuss something just after this presentation. I will try to discuss something which may be giving a flavor as to how a 360-degree approach can be given to any given complex business legal issue. Then I have tried myself an initiative in the name of Student Case Law Expert Series. In the Student Case Law Expert Series, what I observed is the students are designated as case law experts. And you means as a teacher, I give them some provisions around which they have to find out good number of cases, and they will present the cases as and when that topic comes up for discussion. Now, this is something which gives them a lot of interest because they themselves assume to be they themselves they are perceived to be experts, and they really do justice. They identify good cases. They present very good insights about it. When it comes to business education, one important aspect is role play that we always highlight, and we always give them role play assignments, be it let's say a capital reduction or a business resolution in terms of IBC. So we give them a company, a distressed company. We make them several stakeholders, and they are supposed to debate between them. They are supposed to negotiate between them, right? They will be assuming the roles of different stakeholders, like one will be a shareholder, one will be a bank, one will be a secured creditor, one will be an unsecured creditor, and they will come to a consensus as to how much should one sacrifice so that a business can be saved. So I'm talking about the internal reconstruction role plays that we can do, or we are doing, right? So similarly, if it is an acquisition, we designate them as bidders, and they are to acquire a target company. So they will themselves, highlight as to what should be the valuation of the target company, what are the contingent liabilities of the target company, how that target company is going to fit into their strategy, and they will identify what should be the swap ratio or share exchange ratio, and they will put bids, and then there will be an interesting bidding exercise that will go on between some bidders. So role play becomes very interesting exercise for them. With the advent of online education, what we do these days, we do breakout sessions, which is quite available in the Cisco platform itself. We do good breakouts because in the general classroom setting, they do not open up. The students do not open up. So what we do, if we give them breakout sessions, it will be small groups. So they will quite open up, and they will really freely and frankly discuss. And whatever is the group's outcome, they come back and discuss with us in the main session. So breakouts play a very important role in the online system. Similarly, polls, quizzes, online panel discussions. Online panel discussions, we designate few students as panelists, and they discuss as we are discussing right now. So they find it very interesting because they get a lot of importance when they are kept in the panel. So those work really good. Also, students have a habit of making videos. So we give them some assignments in the form of documentaries and all. So they collect information, they give their own voice, they record it very nicely, they edit it also very nicely, and they submit it to us. Sometimes they put it on their YouTube channels. So this can be a very good method of evaluation. Why should we stick to that pen and paper method of evaluation? This becomes a very good method of evaluation. Similarly, recently I conducted a qualitative study with one of my students who is in 4th year. So we interviewed many bank senior, general AGM, assistant general manager, and above levels of managers. So we did a qualitative study in which we conducted interviews with several people. So it was a brilliant experience. So that kind of interviews can be given to them to make qualitative studies. We have tried them for quantitative studies. Now we can give them qualitative studies. And as I told you, storytelling can be a very good method of imparting education. And if we can really, put the story together, it can be a very good method for us. Now, this is what I was trying to do. If I may be permitted, I can give a bit of a glimpse as to how I case studies. This is not a real court case, but how I conduct a case study. Am I audible to all of you?
Yes, sir. You are, sir.
You are audible, sir.
Please, sir.
So can I give a glimpse about how we conduct a case study in the class? Okay. So you see, I always tell that we need to think like the director of a movie. How a director of a movie brings in some amount of excitement, some amount of suspense, right? Some amount of inquisitiveness in the audience. We need to actually think like that, and we need to actually do like that. So generally what I do when introducing accounting and law or commerce and law, I bring this case study for discussion. So I pick it up, I take it from the, I take it as Tech Mahindra. I do not take it as Satyam. I take it as Tech Mahindra. Why Tech Mahindra? Because Tech Mahindra is a company which is existing right now. The current students who are, coming to us 10 years after Satyam or 12, 13 years after Satyam, they would not know what was Satyam. So they know Tech Mahindra. So I start from here, right? So what I tell, you see this company Tech Mahindra, compare its performance of 2009 and 2018. So obviously there will be a question in the minds of the students that why sir is telling me to compare between 2009 and 2018, right? So then I tell them that it was a watershed moment in the history of the Indian financial system when in 2009 the Satyam scam broke out. When Raju confessed on January 9, 2009, that was a watershed moment. Means lot changed in the Indian financial system after 2009. Therefore, I'm asking you to compare between 2009 and 2018. Now, I saw them like this. You see the current position of Tech Mahindra, and I make them read the statement of Anand Mahindra. So they will read it, and if you also yourself read this, what you will find that the moment Tech Mahindra was interested to take up Satyam or take over Satyam, they were in search of inorganic growth. So if they would have organically grown, they would not have been in top 5 at all. So they were in need of inorganic growth, and therefore Tech Mahindra found Satyam on its way. When Satyam scam was, a scam broke out, Tech Mahindra got it as an opportunity, and CP Gurnani was the CEO of Tech Mahindra for a long time, who found it to be a strategic fit and who acquired Satyam at that point of time. Now, with this, the students will be very interested. Some of them would be knowing about Satyam scam in detail, and some of them would not be knowing. So they will then ask, sir, what happened and why, Tech Mahindra went for Satyam when nobody, generally would be interested in taking over a company like Satyam. So then we go back to the next question, that how was Satyam when, the scam broke out? Right. So we tell them, okay, in this also at a later stage or at this stage, if the students are asking us or posing us questions about SEBI takeover code, because it is an acquisition, so the takeover code of SEBI will apply and the open offer will apply, right? SEBI open offer and takeover code will apply. So if they're asking us about open offer and takeover code at this stage, we will briefly discuss about that also, and then proceed to the commercial substance of that particular deal, right? If they're not asking, then we will wait for the bidding process, the acquisition process, and at that point of time, we'll talk about the takeover code. But at this stage, I'll just, this I'll show, and then I'll take them to the flashback. So what is the flashback there? The flashback is 2009, when, this was the situation of Satyam. So you can see year-on-year average growth rate of around 38%, 28, right? 33% growth rate in the net operating margin, net profit, then return on equity, return on capital employed. Every time you see around 30% growth rate the company was showing. Now suddenly what happened? Suddenly you find that there came a confession letter from Ramalinga Raju. right? You suddenly find that there came a confession letter from Ramalinga Raju. Now, when the confession letter came, I also show my students the confession letter, and I make them read that, right? I make them read that. Now, if I may share that letter with you, you will also find it very interesting. And I have a point to make after that. So let me just share it with you first. One second. Yeah. Just a second. I'm just sharing it with you. One second. Can you see the letter now?
It's starting, sir.
It's starting.
Yeah, it's starting. Okay. Okay. So you see, the point why I'm showing this letter here also is because once they read this letter, I ask them, can you identify what should be the charges that should be leveled against Ramalinga Raju? Can you tell me what should be the charges? And I will then show them the CBI charge sheet and then tell that, okay, you are telling falsification of accounts. You see, okay, in the CBI charge sheet also there is falsification of accounts. You are showing criminal breach of trust. You see in the CBI charge sheet also there is criminal breach of trust. And then I will show them the judgment and I'll tell that, okay, whether Ramalinga Raju was found guilty with regard to criminal breach of trust or not, right? So you can please read this first. You know, this is why how Ramalinga Raju confessed to the board of directors on this day. So what he's saying many revealing facts. He is saying that the balance sheet is carrying inflated cash and bank balances of 5,040 crores. He is saying that, you know, there is an accrued interest of around 376 crores. He is saying that there is an understated liability of 1,230 crores. He is saying that there is an overstated debtors position of around 490 crores. So what I do, I analyze these figures and the mechanics as to how liability can be understated, how asset can be overstated, then how cash and bank balances which are non-existent, is it possible that one can show it in the balance sheet for a long time without getting caught by the auditor? So I'll then go back to the accounting standards and then I'll go to the auditing standards to tell what are the auditing standards applicable to it. So what is material and what is not material, what should be disclosed and what should not be disclosed, or how much if you do not disclose it is still fine according to the auditing standards and accounting standards. Right. So we go into those discussions. We while discussing about the mechanics of this particular, the mechanics of the wrongdoing or the window dressing that Raju has done. So I just want to ask, sir, am I on the right track or the expectation was something different and I'm going on a different direction?
No, sir, you are on the right direction, sir, but the PPT is not visible, sir.
Okay, so the Word file is visible here, Word file?
No, sir, no, sir.
Okay,
No,
it's
sir.
not visible, so I am only able to see it. Okay, so not a problem. I'll just.
Yes, sir. I'm also agreeing with you. How the subject, the commerce, can be taught to students through law perspective, right? So you are going right track only, sir.
Okay, so is it on the right track, sir?
Yes, sir. Yes, sir. Yes, sir. Go ahead.
Okay. So you see, there are so many things. So here, this is we talk about from the accounting perspective as to how the scam was hatched. What was the mechanics of the scam? So how he over-reported the profits. Then we tell that if you overstate your profits or over-report your profits on the balance sheets asset side, you have to also create some assets. So we saw the mechanics of the balance sheet and profit and loss account, and we go to the accounting standards, we go to the auditing standards to tell that, okay, this was permitted, this was not permitted, right? So whether the auditors were in connivance in this case, right? So they connived with the promoters to hatch this fraud. So we tell them about these aspects at this stage. Then he goes on, explaining how there was a huge gap between what was real and what was fictitious, and how that gap widened from 2002 to 2008-9, right? So we go on speaking about that. Then we go to the aspect of how he was interested in. Now the word file is visible, I think, sir.
Yes, sir, visible, sir.
Yes. So then we go to the aspect of how he was trying to cover up, because he did this scam right from 2002 till 2008. So how he was trying to cover it up. So we talk about the Maitas infra acquisition deal, which was there, which was going to be a savior. Then at that point of time, how the shareholders blocked the proposal, how the independent directors started leaving. So then we tell about meetings, how board meetings happen. In case of an acquisition proposal, how a majority has to be achieved. So whether it is a simple majority or a 2/3 majority, right? So we talk about the aspects of meeting, then resolutions, meeting, and then voting. We talk about that. And if it is a promoter driven company, how the meetings can be influenced. If it is a shareholder driven company, then how meetings have to be managed. So some tricks about managing the meetings. Then whether this deal, that is Maitas Infra, then we relate it to the global financial crisis, and we tell that 2007-8 the global financial crisis broke out, and this was an infrastructure company which has largely invested in real estate, this Maitas Infra. So for an IT company to acquire a real estate company after the global financial crisis does not make any commercial sense. So we talk about strategy, we talk about commercial sense at that point of time. So this is how a 360-degree approach can be given to a particular topic. Then we also tell about the idle cash balance which was not existing in the company, which Ramalinga Raju was reflecting in the books. So many a times the independent directors told that let's acquire some IT companies which are available at that point of time at low valuations. How Ramalinga Raju was blocking those proposals of the independent directors, right? So we discuss the entire episode, what could have gone in, how the different people, different influential people who were involved with Satyam, how they have been time and again pushing Raju to go for some acquisitions and use the huge cash reserves that he has built. But because this cash reserve was not there, so he was not doing anything, right? So we discuss it like that. Then the deal could not be through, and after the deal was stopped, the attempt to cover up this particular scam is not really succeeded, right? Has not really succeeded. Now did Raju have any alternative other than disclosing the scam to public, or he had some alternatives, right? So that is the discussion that we go to with the students. Then I give them some information about how the World Bank has initiated, has actually brought in red flags with regard to some contracts which Satyam has taken fraudulently from World Bank. And at the same time, SEBI had appointed KPMG to investigate into Satyam and the aborted Maitas acquisition. So all these three things made a situation where Raju had no choice than to confess his crime, right? He had no choice than to confess his crime. Now, if you see the confession itself, he is actually confessing it in detail, and he is saying who should be, given what charge after this. And he is also saying that, neither him nor his spouse, right? They have gained anything unlawfully out of this particular scam. but this is not true. I am going to contest that also in the later slides that I have. So in the confession letter, though he is confessing that he has done it, but he is telling that he has not unlawfully gained anything out of that. And the same is the outcome in the defense arguments also. In the defense arguments, what you find that the lawyers of Raju, they have told that though it is a confession of the scam, but he is not guilty of the scam, right? He is not guilty of the scam. So then, this is because it's only a very small read and a very interesting read. I make this read to the students. The students read it very, very nicely. And after the students read it, then I go to this line that is, I'm now prepared to subject myself to the laws of the land and face consequences thereof. And he is marking this, letter to chairman of Satyam and SEBI and stock exchanges. Now, when you are seeing this kind of a letter, I then ask them, so this is a confession. So if this is a confession, if a person is confessing, is there any need to conduct a trial? Can a conviction be based on a mere confession like this, which Ramalinga Raju is making? If he is pleading not guilty in the trial stage, so what is the evidentiary value of this confession letter, right? What is the evidentiary value of this confession letter? Now, also, I would like to show you in the slides again. Can you see the slides? Okay, I'm sorry. It's not the one. Okay, can you see the slides, sir?
Sir, only the word file is there.
No, sir. Slides are not visible.
Slide is not there, so I'll just have to do it from here, I think. One second, yeah. I think now it will be visible. Now is it visible?
Yes, sir. Now it is, sir.
Okay. So then, I do ask them, because it's now the legal questions around about this particular scam. So I ask them, after going through this letter, what kind of charges you can actually level against this person, that is Ramalinga Raju, and his accomplices. His accomplices include his brother and his auditors and his other accomplices like CFO, etc. Now the students tell me that he can be charged for fraud. So I then ask them, do you have any provision of, do you have, in 2009, it's not 2018 or 19, did you have anything called fraud in any of the laws of the country? It was not there. The best that was available was section 420, which deals with cheating, right? Cheating. Now, though you can extend that to fraud also, but the corporate fraud of this magnitude could not have been addressed by IPC, right? So they then become curious, and then they tell me that, sir, in section 420, the maximum punishment is 7 years. And if you see the outcome of this particular case, the maximum punishment that was given to Ramalinga Raju is also 7 years only. So the best thing that you can find is probably he is punished maximum according to what was the law of the land at that point of time. The section 447, which deals with fraud in the Companies Act of 2013, that came in 2013. Previous under any of these new regulations, right? Or so he therefore got a lenient punishment, right? So then we go on to discuss what is falsification of accounts, what is criminal breach of trust, then what is misrepresentation. We discuss what is class action suits, because with regard to the US investment, and because Satyam was listed in New York Stock Exchange, so there were class action suits, and the Securities and Exchange Commission judgment we also bring and show it to them, how they were fined some $700 million, right, in the United States for while the class action suit was decided against them for providing false information, falsification, misrepresentation, etc. So it gives a holistic view about what are the regulatory regimes that are governing a corporate setup. If anything goes wrong, what is going to be the outcome for the promoter or for the wrongdoer, right? Then after discussing this much, we go to the actions taken by the government, because we need to give them a holistic perspective. So we tell them the first action that is taken by the government is that the MCA is empowered to supersede the board. Under the Companies Act, the MCA, the Ministry of Corporate Affairs, is empowered to supersede the board. Now, supersession of boards, how many occasions there has been supersession of boards? We tell them about the recent incident of Yes Bank and Rana Kapoor, how the board was superseded, right? So many instances of supersession of board and what may lead to supersession of board is discussed with the students at that point of time. So let me also put a disclaimer here that we do not always get 100% participation in all the discussions that we are doing, but many students really participate because they find these areas of interaction very, very interesting, right? So they will bring in some good examples also, so that makes it very interesting. Then we go to the bidding. So once the scam came into light, how the acquisition process kicked off. Once the board was superseded by the government, how the company was then put for sale, and who all were interested to buy this company, right? So, and what was the share price or share exchange ratio that was offered at the time of acquisition, and how the bidding takes place. In the bidding, the eligibility aspects we talk about. Then we talk about the takeover code. We talk about open offer, how open offer has to be made. Then at the same time, we talk about who all participated in the bid and what was their price considerations, what were the price that they really offered, right? So then we come to a conclusion about the process of the bidding, and ultimately it is the Tech Mahindra at that point of time which won the bid, right? And it is actually at 58 rupees per share. Tech Mahindra got this company. Now, after getting this company, we talk some aspects about the due diligence that is required before a company goes into acquisition of this kind of a company, right? So we talk about how you have to identify the contingent liability of such a company, how you have to identify the different contracts under which performance is going to be due after you take it over, because there were simultaneous proceedings with regard to prevention of money laundering. So if it is decided against you, so what kind of impact will be there under the Prevention of Money Laundering Act against the company, right? So legal due diligence becomes very, very important at that point of time. And who better than commerce and law students can really identify the real amount of the liability in case it is decided against the new company, that is Tech Mahindra, right? Tech Mahindra Satyam, because Satyam would no longer exist. So it is the new company that would exist. So they will have to take over all their liabilities in the future. So one needs to get a good estimate of what is going to be the total liabilities in the future, right? So we tell them about the mechanics of acquisition at that point of time and the strategies of acquisition. Then whether it was really a strategic fit or it was not a strategic fit for Mahindra at that point of time, right? So we tell them all those things, and we give them some statements about what was the decision at that point of time. In hindsight, whether Anand Mahindra still believes that it is a good company or not, right? It's a good acquisition deal or not. Then we talk about some leadership styles, like how is the leadership style of Anand Mahindra, how is the leadership style of Ratan Tata, etc. So they become very, very keenly interested in this. Then we take them to the trial. In the trial, what happened, you see, in the Satyam trial, there was a fast track court that was there, and BVLN Chakravarti, the chief metropolitan magistrate, was actually hearing this case, right? And CBI actually filed two charge sheets. One is the original charge sheet, the other one is the supplementary charge sheet. On 7th April, the first charge sheet was filed, and yeah, only 10 minutes more. So I will be only highlighting few more issues, and we'll be concluding this. What are the charges that CBI has put against them? Criminal conspiracy, right? Duping the investors by increasing their confidence, by inflating the revenues of the company, and criminal breach of trust, misrepresentation, falsification, right? So these were the charges that were put by CBI. Some pages of the charge sheet also we show to the students, that that are relevant pages we show it to the students, so that they understand, okay, in case of a corporate crime, what kind of charges can be leveled by the investigating agency. Okay, then we go to the question of if there was a confession, why he was straight away not pleaded guilty, and why there were why there was still a long trial. Supreme Court has actually set a deadline. That deadline was missed, right? So initially, you see 676 witnesses and 3,600 documents were brought in by CBI, but then they reduced it to 226 and 1,532 documents, so that the court can fast track the case. Okay, so that is what they did. Then there were statements of the witnesses, the statements under 313 of CRPC of all 10 accused, right? So even with a very watertight case, the conviction took around 4 years. And we then saw the judgment and relevant parts of the judgment, which really talks about the crime and the punishment that is given against that particular crime. Okay, the Metropolitan Court judgment. Now, you see, there was a simultaneous ED proceeding also, in which ED attached around 822 crores of property, which belonged to the new company. Now the new company also challenged it. It's not alone. Ramalinga Raju who challenged it. Along with them, Tech Mahindra also challenged it, because they told that in good faith, with the support of the government, we took over that company to turn it around, so that such a large company and a large recruiter is not left out in the means the employees should not be given up. Therefore, we took that company. Now with this attachment, we are really going to suffer, because 822 crores of property of ours, if you do not make it free, we will not be able to honor many of our commitments, right? So that is the simultaneous ED proceeding that happened. So we talk about that also. And then we come to the judgment. In the judgment, you see that there was 5.5 crores fine to each of the two brothers, Ramalinga Raju and Rama Raju. And right now, if you see, the person Rama Raju was actually again acquitted by the Supreme Court. Ramalinga Raju is still serving the prison, and it's 7-year imprisonment. He is still serving it. But Rama Raju actually got acquitted by the Supreme Court recently. In 2018 or 19, he got acquitted. Now, why the case took so long? You see, CBI, what kind of charge CBI has put? 10 suspects with collaborating to inflate revenue, fabricating invoices, falsifying accounts and income tax returns, forging fixed deposit receipts, right? Pointing a rosy picture. And these accomplices, like Ramalinga Raju, then G. Ramakrishna, and Rama Raju, were all found guilty for the charges that were leveled against them. Okay, and even they were also found guilty for destruction of evidence also. Now, why it took so long? Why it took so long? And the point is, a problem like this is a complex business legal problem. And please believe me that it's not the only problem which is a complex business legal problem. I'll tell you 50 different problems which are also equally complex business legal problems. And to understand that problem in its entirety, you need a good amount of business legal education. Then only you will be able to do good justice to it. You see, what is CBI saying here? It is a very complicated case involving digital evidence, computer forensics, audit procedures, accounting standards, revenue records, source codes, computer network logs, etc. And therefore, it took a long time for us to actually convince the court that they were guilty of it. Okay. Now, yes. Now, as all of you know, then we go on to discuss what are the legal changes that were brought after this particular scam. We talk about the Companies Act 2013, and we talk about the punishment regime and the corporate liability regime. What happened to the liabilities of the auditors? What happened to the liabilities of independent directors? Right? What happened to the liabilities of promoters? What happened to the transfer of shares? What happened to the pledge of shares that the promoters were able to do before, and how it has been affected after the Companies Act 2013 came into picture, right? We tell about all those things at that point of time. And then really help corporates in avoiding such huge crimes, right? Avoiding such huge crimes. Now, dear participants, I don't think this is the only issue that I wanted to discuss with you. There are many issues like this. I can again give an example of IBC. If you see a resolution plan, imagine Jet Airways. If you take the Jet Airways case study, how many different aspects are involved in that? How many different interests of creditors, interests of banks, interests of the promoters, employees. So if you combine everything very, very nicely, what happens? The students can really get a very nice 360-degree view about the entire problem. Similarly, there are some subjects in commerce and law which are inherently interdisciplinary. I mean to say, if I'm talking about income tax, so income tax has one area that is practice. The other area of income tax is the theory or the principles or the provisions of Income Tax Act, right? So that is inherently interdisciplinary. You don't need to make it interdisciplinary. But areas like this and many areas like this I can bring, let's say an IPO, an initial public offer. If you are speaking about an IPO, you can talk about the SEBI regulations, you can talk about the ICDR guidelines, you can talk about the listing agreement, what are the conditions under the listing agreement, right? So a lot of things can be brought in, and then you can tell about the shareholders valuation, right? You can tell about how the markets have perceived it. Then you can talk about investment banking, merchant banking in the context of the IPO. And you can talk about the regulations which are governing these IPO issues, right? If it is an IDR, Indian Depository Receipts, what are the regulations? If it is ADR, GDR, what are the international regulations applicable to them? So there are lots of possibilities that can be really explored with regard to commerce and law. And one thing, you please believe me that, one thing this education has been creating in our university, we have been observing it since I am there since 2007. I have been observing that, a lot of students create real career interests in commercial and, business laws post joining BCom LLB or BB LLB. You can say that they come with the interest of corporate and, therefore they join BCom and BB LLB. But if you give them this orientation right throughout the entire period of their study, their inclination becomes quite stronger. and they flourish in their areas of practice also when they join law firms or banks or SEBI. One student of ours is in SEBI who did become with us. He's very successful there because he understands how the markets play mischiefs, right? How the markets play mischiefs, how the companies play mischiefs. So he will be a very good regulator if he joins, if he is there in SEBI. So possibilities are endless in this particular aspect. I would like to take a few questions if you have, if you permit me.
Yes, sir. Yes, sir. Participants, if you have any query, then please raise.
Yes, sir. Really, law and commerce subjects are interdisciplinary. When we had a barter system to feed our needs and wants, we didn't have much problem on education. Once we found a common currency notes or gold to try to purchase whatever we need. So the problems were raised. So from that point onward, we have a need of all these laws. So we are studying in commerce. We are studying in traditional universities. The students are studying in commerce, international market, and international finance, and marketing, and everything they are studying. So without having the idea about various acts and laws which are relating to international trade and international marketing and the banking, they cannot acquire the full idea about this concept. And also law graduates, if they wanted to do anything in international law or banking law or IPR, they also should have the basic idea about these concepts. For example, if you want to get success in the IPR, so simply we cannot say that I can follow all these regulation provisions without understanding how to fix the royalty, or how to collect the royalty, or how to calculate. So
Yeah,
first,
absolutely.
how to market this type of products, then only they can the idea. So really, your lecture help us to understand how these two disciplines are interrelated and correlated. Thank you, sir.
Thank you so much.
Thank you.
One aspect that you highlighted is IP. Let me tell you, if you do not commercially understand whether you should actually sell the IP, license it out at a royalty, or you should produce yourself, or you should partner with somebody, some established market player, you cannot really make a good use of the IP. Just having it doesn't mean anything. How you will put it to commercial use, how you will put it to commercial exploitation, right? That is what is the most important aspect, financial aspect involved in the IP. So a holistic understanding is really needed in that also. Yes, sir. Go ahead. Yeah.
Thank you, sir, for your interesting and enthusiastic talk on interconnections between the law and economics. Now, I request Mr. Rahil Raj, Assistant Professor of Law, to propose the vote of thanks. Rahil Raj, sir.
Yes, sir. Thank you, sir. Thank you, sir. I, Royal Raj, deem it a privilege to deliver the vote of thanks on behalf of the Faculty Improvement Committee of Tamil Nadu National Law University. I express my heartfelt gratitude to our resource person, Mr. Satya Ranjan Mishra, Assistant Professor of Commerce at TNNLU, for sharing his valuable insights on the title Law and Commerce. So, throughout the course of presentation, sir's rich experience was all the more evident, and sir's talk was also all the more practical, and it was highly relevant to us. The case study of Satya made it all the more interesting, brilliantly connecting law and commerce. Thank you, sir, thank you once again for your enlightening lecture. I also thank all the participants for their cooperation in the smooth conduct of the session. Thank you once again.
Thank you so much.
Thank you, Rahil, sir. Thank you, Satya, sir. Since we are running out of time, we are having another session at 3 o'clock. So that is the we are rushing, sir.
Yes, sir. Please go ahead and Thank you
Yes,
so much.
sir.
Thank you so much.
Thank you, sir. Thank you, sir. Now I request all the participants to join the next session by using the link that we have shared in the chat box. Please join. Thank you all. Felix, sir. Felix, sir.
Yes, sir. Yes, sir.
Sir, please end the session, sir.
Yes, sir. Thank you, sir. Thank you, sir.
Thank you, sir.